Good afternoon, everyone. I come to you today to bring you truly excellent news that those of us who practice in the asylum world have been waiting for months. The current Attorney General, Merrick Garland, has vacated two of the truly terrible asylum decisions that were issued under the Trump administration, matter of AB and matter of AB2, and matter of LEA2. The vacating of these two decisions brings a renewed hope that victims of gang violence and victims of gender violence will be able to successfully pursue asylum claims in the United States. That is a welcome relief to all of us who practice in the asylum arena. Very quickly, just to give you a few of the specifics on these cases, matter of LEA involved a claim that people could qualify for asylum if they were being harmed because of their family ties. So this is very common when one family member might be being extorted by a gang member, and then as leverage to get that person to comply with the extortion demands, the gang threatens to harm or actually harms a relative of that person. This vacating of matter of LEA2 brings back hope that the relative who was threatened or harmed simply as leverage to get the first relative to pay an extortion fee may qualify for asylum. That is just one example of how a family-based asylum claim might work. And then the vacating of matter of AB and AB2 has really very broad implications for asylum law. At the most superficial level, they restore a prior case called matter of ARCG that recognized that domestic violence in certain circumstances could be a basis for asylum in the United States. That is wonderful. More on a broader level, it may open the door to other claims related to gender violence outside of a domestic violence context. It also eliminates what was seen pretty widely as a presumption that gang-based asylum claims could never be granted. That is also very welcome news. The vacature orders in both of these cases recognize that there is rulemaking going on right now at the Department of Homeland Security that relates to when gang violence and when gender violence could qualify someone for asylum. We are eagerly awaiting the publication of those rules. We hope they'll bring some clarity to this otherwise very murky and confused area of law, and we hope that clarity will be long-lasting and won't result in this ping-ponging back and forth between different administrations where gender violence or gang claims seem to be grantable and then all of a sudden they're not grantable. And of course, we hope that the regulations will strongly recognize that gender violence and gang violence should be grounds for qualifying for asylum in the United States. In any case, if you or someone you know has been thinking about whether or not they can apply for asylum in the United States, whether they should apply for asylum in the United States, please have them call our office for a consultation, 323-475-8716. It's very important that people get timely advice about their eligibility for asylum. The United States has a law that requires people to apply for asylum within 1 year of entry. There are certain exceptions to that rule, but if you don't meet that 1 year deadline, it becomes increasingly more difficult to qualify for asylum. So the importance of getting timely consultation, timely advice on an individual's asylum case cannot be overstated. Again, my office is happy to schedule consultations for folks that may want to understand how these new vacatures of old decisions by the current Attorney General helps or doesn't help their case. Hopefully helps. So please call us 323-475-8716. Thank you so much, everyone, and have a wonderful day.